Hello! Now we've reached the part in this video series about the case in chief. This is the part of a trial when the evidence, including witness testimony, is presented. This is the part that is most often dramatized in books, movies, and on television. It begins with the prosecutor presenting the evidence to tell the story of the crime, to establish that a crime was committed and that the defendant is the one who did it. That evidence may include audio messages, recorded phone calls, closed-circuit camera video, interview recordings, photos, charts, body maps, medical records, actual physical objects from the crime scene, clothing, you name it. But the means of introducing those other forms of evidence is usually through witness testimony. In other words, instead of just handing the jury photos of a crime scene, they will have the police officer who took the photos come into the witness stand and testify that they took the photos of the scene and that these are indeed the photos. This process is important for showing how the evidence was gathered, that it accurately reflects the crime, that there are scientific standards for how evidence is collected and examined, and that it hasn't been tampered with. Prosecutors will spend particular time on this when one of the arguments of the defense is that the evidence itself is inaccurate or false. The prosecutor gets to go first in presenting the case, and that means that they get to call their witnesses first and ask them questions first. So the prosecutor calls a witness, asks them questions, which is called the direct exam. Then the defense gets a turn to ask them questions, which is called cross-examination. When the defense is done, the prosecutor again has a chance to ask questions. This is called redirect. But they can only follow up on issues that were brought out in the cross-examination. They can't go back and add in new issues that they forgot to ask or wish they'd asked during their direct exam. What kind of questions can be asked? The judge has a lot of control over this, based on what is called the rules of evidence. These rules don't allow an attorney to ask their own witness any question that implies or suggests that they give a particular answer. That's called a leading question, though the opposing attorney can ask leading questions during cross-examination.
Your Honor.
An attorney can ask the judge to stop a question by objecting. Let's pause and take a couple minutes to talk about evidence.
I object, Your Honor.
In television court dramas, there's frequently a moment when the defense or the prosecution will suddenly produce a piece of evidence or ask a surprise witness to the stand that totally changes the outcome and saves the day for whatever side the audience is supposed to be on. That does not happen. Both sides know what evidence the other side has and what witnesses they may call. They've had a chance to examine the evidence and question those witnesses beforehand. Surprises simply are not allowed. And if they should be, it's a reason for the whole trial to be thrown out and started over. So, surprise evidence is one kind of evidence that isn't allowed. Another kind of evidence that is not allowed is called prejudicial. Prejudicial evidence is information that would bias the jury against the defendant. Things like a previous history of drug use. There's a lot of case law in history on what kinds of things are prejudicial, and when and how certain evidence that might be unfair can enter into a case. For example, if someone has a previous history of violence toward partners, is it fair to let the jury know that in relation to whether they committed this particular assault on this particular day? A third kind of evidence that is not allowed is hearsay. A witness can only testify about what they personally know. Saying that someone else said something happened can't be used as evidence to prove that it's true. As with prejudicial evidence, it can be complicated, and there are certain things that are allowed even though they qualify as hearsay. An example of this is called excited utterance. The court assumes that something said in the heat of the moment in crisis about a crime is true because people are too upset or overwhelmed to lie. So a police officer who responded to a scene can testify that the victim told them the defendant knocked them down, and that can be used as proof. But if the victim's grandma testifies that the victim said the same thing last week, that is hearsay. When the judge does not allow evidence to be presented or included as part of a case, that evidence is said to be inadmissible. Most of the decisions about what evidence will be allowed and what will not takes place before the trial even starts. The attorneys have already submitted requests to the judge about what can or can't be used. This is a way of limiting how many times a jury hears about a piece of evidence or starts to hear testimony that is stopped and then ruled inadmissible. If it does happen that a jury is exposed to something that is then determined to be inadmissible, they'll be told to ignore it and not include that evidence when they are making their decision. But you know how hard it is not to think about something. This is why, as much as possible, the judge has already made those decisions before the trial. Okay, so back to the rhythm of the trial. The prosecutor calls a witness. The defense cross-examines. The prosecutor redirects. This continues until the prosecution has presented all the evidence in the case they are going to use. They have told their story of the case to the jury. The prosecution is said to rest. At this point, it is normal for the defense to ask the judge to dismiss the case based on not having enough evidence, illegal evidence, credibility of witnesses, etc. This is standard procedure. It's also extremely rare for a judge to agree. Now it's time for the defense case, and the roles are reversed. The defense calls a witness. The prosecutor cross-examines. The defense redirects until the defense is also finished. The defense may tell a whole different story to the jury, but remember that they don't need to. The burden of proving the case is on the prosecution. All the defense has to do is create enough reasonable doubt. The defense attorney may feel they did much of this during their cross-examination of the prosecutor's witnesses. And of course, a defendant is not required to testify if they choose not to. So the defense case may not take as long to present as the prosecution. When the defense is finished, they rest as well. The final round of the case in chief is called rebuttal. Like redirect, the prosecution has a chance to address any issues that were raised during the defense case. They can call witnesses back to the stand and go over evidence that was submitted to clarify or attack the credibility of a witness. Then, the defense has a countering opportunity. Rebuttal is frequently short. That leads us to the next stage of the trial, the closing arguments. Like the opening statement, this is an opportunity for each attorney to summarize the evidence and facts presented, highlight the elements they think are most important to tell their story, and persuade the jury to make a decision for their side. Since this is the last opportunity to sway the jury, closing arguments tend to be the most dramatic and directive part of the trial. In the next video, we'll go over the jury instructions and deliberations.